Hello, everyone. Welcome back to Ask Prashanthi. I'm your host, Prashanthi Reddy. I'm an immigration attorney, and I'm dedicated to helping you navigate the sometimes challenging and often rewarding world of US immigration law. In this show, we tackle all your questions, your pressing concerns about visas, green cards, citizenship, and everything else in between. We pull questions from all our channels, from right here on YouTube, from LinkedIn, Facebook, Instagram, and of course, those excellent submissions from my website. So if you have a burning question, make sure you submit it and you will hear it answered in the next episode. So let's go and address the first question that we have. This came from my website and it's from Arjun. Arjun says, I'm currently working for a non-profit organization on a non-cap H-1B visa that expired in June 2025. My employer filed an extension before the expiration date, but the petition is still pending. I'm now working under the 240 grace period rule. If I remain in the US during this process, would another nonprofit organization be able to file a new cap H1B petition for me, a new non-cap H1B petition for me within the 240-day grace period? What about after the 240-day grace period expires? So, Arjun, all good questions. First, you have to understand that the 240-day grace period applies for H1B extensions, and within the 240 days, if your H1B has been pending for 240 days, you can still continue to work. But after the 240 days, you cannot work. So it's only related to your working status. It has nothing to do with whether you file a H1 transfer or not within the 240 days or after the 240 days. So if you wanted to file a H1B transfer because your I-94 is expired and you will not be able to file a transfer based on a valid I-94, you have to file it based on the receipt notice because you now don't have an I-94. So if you're doing that, then it's called a bridging petition because you're filing another petition based on a pending petition. And with reference to these cases, though it has nothing to do with the 240 days, they do sometimes send an RFE asking for the approval. So it might be a good idea for you to speed along your existing approval by, converting into premium processing if possible. So then when you get that RFE, you'll be able to respond to it with the actual approval. If you're not able to do that for some reason because your employer doesn't want to do that, then you'd have to go with the bridging petition. You have to explain to USCIS if there is an RFE that this is a bridging petition based on an already pending petition, and there is some law with reference to that. So good luck if you plan to do an extension or a transfer based on a pending petition. The next question is from Suresh Reddy, and this question was posted on my website. And Suresh says, I filed at AOS, adjustment of status, 5 years ago when my priority date of February 2013 was current under EB3 due to a downgrade. After a few years, EB2 became current, so I interfiled and switched my 485 from EB2 using the 485J form. However, after a few months, all the dates retrogressed, as we know. It's a seesaw between EB2 and EB3. I have an approved I-140 petition under both EB2 and EB3. Good for you. 1 year ago, I took a full-time job. Now I have a new employer. They have filed an interfile request for my job change. My 485 is currently under EB2, but since EB2 retrogressed, while EB3 has been current for my date for the past few months, my question is, can my new employer submit another interfile request to have my 485 considered under EB3, allowing me to get my green card more quickly? Yes, absolutely. You can file for transfer of underlying status using your 485J form, and this can be done by your new employer. And this should be done ASAP. You shouldn't have waited for a few months to do it, but I guess you might have just changed jobs and therefore maybe the wait. But yes, you should do it ASAP. But having said that, USCIS is basically supposed to track all the I-140s you have, and then they're supposed to use the 485, the I-140 with the best priority date. So they do that anyway, but there's no harm in moving it along by filing a transfer of underlying status request. The next question is from Desiree, and this was also posted on my website. My question is about the following situation. H1B I-94 expired in October 2024. Employer timely filed an extension of status for the employee. In February 2025, while the extension was still pending with USCIS, the employment was terminated. In such case, does the up to 60-day discretionary extension still apply? So the person is asking if they have 60-day discretionary period to find another employer after termination, but the catch in this situation is that the I-94 is expired. So unfortunately, you can only use the 60 days grace period to file a new petition after expiry or after being laid off or after leaving or termination of employment. Only if your I-94 is valid. If your I-94 is not valid, then you're pretty much out of status, and the 60 days grace period will not help you. Next question is from SP, and the question also was posted on my website. I have an unused H1B I-797 approval, which was approved in 2014 when I was in the US. I have an employer now in 2026 who's ready to sponsor my visa. Can I use the previously unused H1B petition, or do I need to go through a lottery? Well, technically speaking, if you were counted towards a lottery earlier, then you will be cap exempt, so you don't have to go to the lottery again. You can simply file another H1B petition, include your H1B approval from 2014, and then ask for the H1B petition to be approved as your cap exempt. Having said this, the definition of cap exempt petitions keeps changing depending on the administration. They're still following a very liberal definition, so these cases are getting approved. So I would go ahead and give it a shot. I hope that helped. Next question is from Raisa Khatun, and this is also posted on my website. If you don't have a job, you cannot extend your H2B. You could change status to B2 or F1 or some other status that is appropriate to your circumstances, or you can leave and come back on H2B when you have another job. I guess this is more like an answer than a question. So I guess the person simply wants me to reconfirm if this is correct, and yes, you're absolutely correct. If you're not able to extend your H2B because your job has been terminated and you are not able to get another H2B job, you can definitely change to a B2 status for 6 months to a year. You can also move to an F1 as long as you do this while your H2B is still valid and the I-94 is still valid. And of course, you can leave and come back again on a new H2B. Maybe with the same employer, it'll be easier. Then you don't have to go through the entire certification process. Or if it's through a new employer, then you might have to go through the entire process and get a H2B and come back into the US. And that brings us to the end of another episode of Ask Prashanthi. I genuinely hope that the questions we answered today were useful to you. Remember, understanding your options is the first step, but getting reliable information is the next step. So always keep yourself informed, always follow reputed sources to get information on US immigration. If you have a question you want answered on the show, don't hesitate to reach out. You can leave a comment right here on YouTube or connect with us on LinkedIn or Facebook, or submit your questions directly on my website. You can follow the link in the description of this video. Thank you again, and keep watching, and I'll see you again next week. Please give me those interesting questions so I can answer them in the next episode. Thank you. Bye.